The
Lord,
judge
it
needs
is a matter of, my lord, institutional respect. It's not a matter of one honorable judge or another honorable judge. Lord, this needs to be dismissed with cost. And with, my lord, I'm urging that contempt action be initiated. Scandalous allegations, contemptuous averments, my lord, is also held guilty. Social media, you need only three things. You need a mobile, which is smartphone. You need data, and you need lot of time. Not that your lordship delivered two judgments and there were some observations, and therefore now I apprehend that you will not be able to do justice. It is also well settled that every application expressing apprehension of bias must be decided on the facts and circumstances of the individual case. These are principles which must guide the consideration of these applications. Your ladyship has passed several orders in this case in favor of the respective parties. Again, that is not a test, that is not a ground. Even all orders go against a particular accused. That is no ground for apprehending bias. It has to be an intelligent, reasonable man conceiving the facts as they exist. I don't want to escalate to this, my lord. But even a lawyer who signs such application which contains scandalous allegations, contemptuous averments, my lord, is also held guilty. I'm not, my lord, pitching that high in this case because, my lord, I'm then, my lord.
the crux of your argument is this only, merely because they are saying that you recuse, the judge need, or please write.
Lord,
judge
it
need-
is a matter of, my lord, institutional respect. It's not a matter of one honorable judge or another honorable judge.
Yes.
Lord, there are several things going on in the country. My lord, sometimes relatives of the judges take huge fees to file their appearances. It's an easier way. But some lawyers, my lord, prefer to get small fees and work harder. It's a question of, my lord, how the system is made to function with honesty. And not anyone, if my lord, if this is the, my lord, standard, some insinuations and some what is the public feeling, would the court decide cases based upon what public feels? Are they representative who have taken a vote that this is what the public feels? Maybe few social media posts. For social media, you need only three things. You need a mobile, which is smartphone. You need data, and you need lot of time. If three are there, then you have social media. You criticize Donald Trump also. You do not manage your own budget, home budget, but you will say that this Dr. Manmohan Singh did not decide properly about budgeting provisions. So this is all, my lord, this is a imaginary world. We don't go by the media posts. And, my lord, now, my lord, yes, my lord, there is one factor. My lord, one of the argument was that your ladyship gave short dates.
Yes.
So that was one of the arguments, and that, my lord, requires to be viewed very, very seriously. The reason is that high courts and trial courts are under a mandate. Mandate may perhaps not be an accurate word, but almost.
Persons on this side know that I have given them even shorter dates than this date in their many other cases.
Lord, in
Without
MP,
any objection.
in MP MLA cases,
Yeah.
Lord, this is what page 10, the Honorable Supreme Court has directed. Yeah, what your ladyships are doing,
Sending order.
other cases are, the people do not understand this. This bench is not taking up only MP MLA cases. Other cases of the similar nature also come. There, it is possible your ladyship may grant 1 month, 2 months, whatever. But now there is Ashwini Kumar Upadhyay versus Union of India, where there is a direction. In fact, there are no two views about the compelling need to take up and dispose of the subject cases expeditiously.
Actually, there is a standing order.
Standing order on the administrative side.
Which is I am bound to follow.
So, my lord, this comparison that in I have produced a chart, 5 cases you ladyship granted 1 month, I am granted 2 weeks. No, that is comparing orange with apples with oranges. MP MLA stands on a different footing. So, my lord, in my respectful submission, my lord, this needs to be dismissed with cost. And with, my lord, I am urging that contempt action be initiated. In refusing, my lord, why I say so, and see the catastrophic result, acceptance of such a juvenile argument, if I am permitted to say so, is accepted. Please have a look at my affidavit in reply, which has remained unrebutted, and I have placed on affidavit. I don't wish to name annexure 2 of my affidavit to this recusal application, and nobody has disputed this because it is not disputable. These are all facts on record. Lord, look at the honorable judges from the Supreme Court to this honorable court and other high courts who have attended the functions organized by Adhivakta Parishad, which is a bar association, and spoken on the subjects of law. Please have a look, my lord, page 19. Lord, this is when your ladyship attended. Please have a look, my lord, on the Chief Justice. I don't want to name, and I am not, my lord, here to sensationalize anything. But please have a look. Then please have a look at, my lord, page 20. Another honorable judge of this honorable court. Would this judge also be disqualified because she participated in a function organized by Adhivakta Parishad? My lord, that is, women advocates in the legal arena was the subject. It was not a subject of any particular political party's ideology. Otherwise, no judge would, honorable judge would accept it. And next, please have a look, my lord, one sitting honorable judge of the Supreme Court with your ladyship, and the subject was same. My lord, if my learned friend is serious about this contention, then let him make a statement, especially respondent number 18, that honorable judges who have attended Adhivakta Parishad, the orders passed by them in his case should be recorded. I have no difficulty. Because I don't want to again sensationalize. His bail is granted by one of the honorable judges of the Supreme Court who attended the Adhivakta Parishad. Can this, I'm posing a question to myself, it's, my lord, disheartening that someone has the, my lord, I'll not use any explored adjective, but someone can even raise this contention. Please, my lord, have a look at the, my lord, luminaries who attend this function, and most of them are, my lord, sitting judges. Then, now please come to my note, my lord, so that I can quickly complete that. My lord, before that, one more fact. The Honorable Court's first order dated 9th April, which
March.
9th March, which I would not term as ex parte order because they were served, they chose not to remain present to oppose either issuance of notice or pass any interim order. And the Honorable Court could have, in law, stayed the order of remand itself. But that remand was not either prayed for being stayed, I'm sorry, not remand, discharge. Neither a prayer was made, because we also are responsible in making our prayers, nor the Honorable Court ever considered discharge being stayed. And therefore, whatever interim order is passed is of such a nature that it does not cause any prejudice to them. That all right, no adverse observations against the CBI till the Honorable Court decides, and till then, finality be not given to ED proceedings. That's the only order. Now, this order, my lord, was passed on 9th March, and immediately thereafter, on 10th March, Mr. Arvind Kejriwal, I'm sorry, I generally don't name the litigants, and Mr. Sisodia, if I'm not wrong, moves the Honorable Chief Justice that please remove this matter from this bench and put it before another bench. The learned Chief Justice passes an order on 13th of March 26. Immediately on the next day, two proceedings are filed. Please come to page 3.